Sir, I need you to turn off that engine, now.
Officer, can you tell me why you pulled me over?
I'll ask the questions. License and registration.
But I'd like to know the reason for this stop. Step off the bike. Step off now. On what basis I'm asserting my Fourth Amendment right?
The motorcyclist's voice remained steady, measured. The officer's was already raised. And this stop had barely begun. What the officer didn't know, what he couldn't have known from the helmet, the leather jacket, the black man on a motorcycle, was that this traffic stop would end with a consequence he couldn't have imagined. That the body cam recording every word would become evidence in federal court. That the man he was treating like a suspect was a judge, and that every aggressive command, every dismissive tone, every constitutional violation was being documented in real time. This wasn't just a bad stop. It was an expensive mistake. 20 minutes earlier, Judge Terrence Walker had been enjoying a weekend ride through the suburbs of Durham, North Carolina. It was a Saturday afternoon in late spring, clear skies, light traffic, perfect weather for a motorcycle enthusiast to unwind after a demanding week on the bench. Judge Walker, 52, had served as a district court judge for nearly 8 years. He was respected in legal circles, known for his fairness and his meticulous application of constitutional law. Off the bench, he was a husband, a father, and a longtime motorcycle rider who took pride in maintaining his bike and riding responsibly. At approximately 3:47 p.m., Officer Kyle Brennan of the Durham Police Department initiated a traffic stop. Brennan, a 5-year veteran of the force, activated his lights after observing the motorcycle on a residential stretch of road. The stated reason: suspected lane weaving and failure to signal. From Brennan's perspective, this seemed routine. A motorcyclist, a minor infraction, a quick stop, maybe a warning, maybe a citation. He had no reason to think this would be anything else. But the body cam strapped to his chest was already recording, and what it would capture over the next 12 minutes would become a textbook example of how discretion, bias, and ego can transform a minor encounter into a civil rights violation. From the moment Officer Brennan approached, the tone was set not by what Judge Walker did, but by what Brennan assumed. "Keep your hands where I can see them," Brennan said, before Walker had even removed his helmet. Walker complied. He slowly lifted his visor, removed his helmet, and placed both hands on the handlebars. "License and registration," Brennan said flatly. "Certainly, officer," Walker replied. "Can you tell me what I'm being stopped for?" It was a reasonable question, a lawful one. Citizens have the right to know the basis for a traffic stop. But Brennan's response wasn't informative, it was dismissive. "I'll tell you in a minute. Right now, I need your documents." Walker reached slowly toward his jacket pocket, narrating his movements. "I'm reaching for my wallet now. It's in my inside pocket. Don't make any sudden moves." I'm complying." The exchange was calm on Walker's end, but Brennan's body language told a different story. His hand hovered near his duty belt. His stance was rigid. His voice carried an edge that suggested irritation rather than caution. When Walker handed over his license, Brennan studied it for a long moment, then looked back at Walker with narrowed eyes. "This your bike?" "Yes." "You got proof of that?" "The registration is right there with the license." Brennan glanced at it, then back at Walker. "Where are you coming from?" "I've been riding through the area. Is there a problem, officer?" "I'm asking the questions." This was the officer's first mistake. Under the Fourth Amendment, a traffic stop must be justified by reasonable suspicion of a violation. Once that suspicion is addressed through documentation check or citation, the stop must end unless new, articulable suspicion arises. But Brennan wasn't treating this as a traffic stop. He was treating it as an interrogation. And the questions he asked had nothing to do with lane weaving or turn signals. "Where do you live?" "Why is that relevant to this stop?" "Because I'm asking." Walker's tone remained even. "Officer, I'd like to know what violation I'm being stopped for." Brennan's jaw tightened. "You were weaving in your lane. Looked like you might be impaired." "I'm not impaired. I'm happy to take any test you'd like." "We'll see about that." But Brennan didn't administer a sobriety test. He didn't check Walker's eyes for signs of intoxication. He didn't ask him to perform any field evaluations. Instead, he kept asking questions. "Who owns this bike?" "I just told you I do." "You got proof of insurance?" "It's with the registration." Brennan flipped through the documents again, slowly, as if searching for something that wasn't there. The stop had now lasted over 4 minutes. No citation had been written, no warning issued, no legal basis for continued detention articulated. Walker remained calm, but he was no longer passive. "Officer Brennan," he said, reading the nameplate, "am I free to go?" And that question, that perfectly legal, constitutionally protected question, seemed to irritate Brennan even more. "You'll leave when I say you can leave." At this point in the stop, nothing illegal had been found. No contraband, no outstanding warrants, no evidence of impairment. Just a black man on a motorcycle, asking why he was being detained. So ask yourself this: was this really about a lane weaving violation or something else entirely? Judge Walker knew exactly what was happening. He'd seen it countless times from the bench officers, prolonging stops without justification, fishing for probable cause that didn't exist, conflating questions with defiance, and now he was experiencing it firsthand. "Officer, I'm going to be very clear with you," Walker said, his voice steady and precise. "Under Terry versus Ohio and Rodriguez versus United States, you are required to have reasonable suspicion to detain me, and that detention cannot be prolonged beyond the time necessary to address the original infraction. You've checked my license and registration. You've confirmed I'm the owner of this vehicle. You have not issued a citation or a warning. So I'm asking again, am I free to go?" Brennan stared at him. For a moment, the body cam captured pure silence. Then Brennan scoffed. "Oh, so you're a lawyer now. I'm someone who knows my rights." "Your rights," Brennan repeated, his tone mocking. "Your rights don't mean you get to tell me how to do my job." But that's exactly what rights do. They limit government power. They define the boundaries of lawful authority. And Brennan was stepping over those boundaries with every passing second. The law is clear. Once the purpose of a traffic stop is complete, continued detention becomes an illegal seizure unless the officer develops new, independent, reasonable suspicion. Asking general questions, "Where are you going? Where have you been?" does not satisfy that standard. Neither does a hunch, a feeling, or discomfort with a citizen asserting their rights. Brennan had no new suspicion. He had no evidence. What he had was irritation, and that's not a legal justification. "I'm going to need you to step off the bike," Brennan said. "On what basis?" "Officer safety." Walker didn't move. Officer safety requires specific, articulable facts suggesting a threat. What threat am I posing? Brennan's face flushed. "You're being argumentative. I'm asserting my Fourth Amendment rights. That's not a crime. Step off the bike or I'll remove you myself." This was the critical moment. Brennan wasn't conducting a traffic stop anymore. He was retaliating. Retaliation for Walker's refusal to submit to unlawful authority. Retaliation for Walker knowing the law. Retaliation, perhaps, for simply being a black man who wouldn't defer. The body cam captured it all. The absence of probable cause, the lack of reasonable suspicion, the prolonged detention, the escalation driven not by safety concerns, but by ego. Walker finally dismounted, his movements slow and deliberate. "I'm complying under protest. This is an unlawful detention." "Save it for your lawyer," Brennan muttered. But Walker didn't need a lawyer in that moment. He was the lawyer. With Judge Walker now off the bike, Officer Brennan circled the motorcycle, inspecting it with exaggerated scrutiny. He checked the lights, the mirrors, the license plate. He peered into the storage compartment. "You got anything illegal in here?" "No." "Mind if I take a look?" "Actually, I do mind. You don't have probable cause to search." Brennan straightened, his hand still resting on the seat. "So you do have something to hide." "That's not how the Fourth Amendment works, officer. Refusal to consent to a search is not evidence of guilt. It's a constitutional right." The exchange was being documented in high definition. Every word, every gesture, every unconstitutional fishing expedition. Brennan stepped closer, his posture aggressive. "You know what? I think you're being evasive. I think there's more going on here than a traffic stop." "Based on what evidence?" "Based on my training and experience." It's a phrase officers often use, training and experience, as if it were a magic incantation that justifies any action. But courts have consistently held that training and experience must be tied to specific, observable facts. A hunch is not enough. A feeling is not enough. And irritation at a citizen who knows their rights is definitely not enough. Walker stood with his arms at his sides, his voice still calm. "Officer, you've now detained me for over 8 minutes. You have not cited me for any violation. You have not articulated any new suspicion. You are violating my constitutional rights, and this entire interaction is being recorded." Brennan's eyes flicked to his body cam, as if he'd momentarily forgotten it was there. "I don't care what's being recorded," he said. "I'm conducting a lawful stop." "No," Walker said quietly. "You're not." This was the moment everything changed. Not because Walker raised his voice, not because he resisted, but because the truth was now undeniable, captured on video, time-stamped and documented. Officer Brennan had crossed the line from enforcement to harassment, and there was no walking it back. Officer Brennan walked back to his patrol car, ostensibly to write a citation. Judge Walker remained by his motorcycle, hands visible, posture relaxed despite the ongoing violation of his rights. Minutes passed. Brennan sat in his vehicle, occasionally glancing up at Walker through the windshield. The body cam audio picked up the rustle of paperwork, the click of a keyboard. Then Brennan's radio crackled. A dispatcher's voice. "Unit 47, be advised registered owner of that vehicle is flagged in the system. Shows judicial credentials. Confirm." There was a pause. A long one. Brennan keyed his radio. "Say again." "Owner is a sitting district court judge, Judge Terrence Walker, Durham County." Brennan's hand froze over the keyboard. His head turned slowly toward the windshield, toward the man still standing calmly beside the motorcycle. He sat there for 10 seconds, 15, 20. Then he opened the door and walked back. His entire demeanor had changed. The aggressive posture was gone, the edge in his voice gone. When he spoke, it was quieter, almost careful. "Sir, I just got some information back." Walker said nothing, just waited. "It says here you're a judge?" "That's correct." Brennan swallowed. I mean, you didn't mention that." "I shouldn't have to," Walker said evenly. "My rights don't depend on my profession." Brennan shifted his weight, glancing down at the citation pad in his hand. "Right. Of course. Look, this was a routine stop. You understand that, right?" "What I understand," Walker said, "is that you detained me without reasonable suspicion, prolonged the stop without legal justification, attempted to search my property without probable cause, and retaliated against me for asserting my constitutional rights. And all of it is on camera." Brennan's face went pale. "Sir, I was just doing my job." "No," Walker interrupted, his voice still calm but firm. "You were doing something else." The body cam captured Brennan's hand moving to his belt, then dropping. Captured him looking away, then back. Captured the exact moment he realized the magnitude of his mistake. "Am I free to go now, officer?" Brennan hesitated, then nodded. Yes, you're free to go." "Am I being cited?" Another pause. No citation." "Then I'll be leaving." Walker put his helmet back on, started the motorcycle, and rode away. Behind him, Officer Brennan stood in the road, staring after him as the body cam recorded his silent realization. He'd just harassed a judge, and every second of it was on video. Officer Brennan didn't move for a full minute after Judge Walker rode away. The body cam showed him standing there, hand on his hip, staring down the empty road. Then he walked slowly back to his patrol car. No citation written, no warning issued, no arrest made. Just 12 minutes of documented constitutional violations and the growing awareness that this wasn't going to end quietly. Brennan sat in his car. The camera caught him rubbing his face, exhaling slowly. His hand hovered over the radio, then pulled back. He knew what was coming. Judge Walker didn't file a complaint that afternoon. He went home, spent the evening with his family, and took the weekend to think about what had happened. But by Monday morning, he'd made his decision. He contacted the Durham Police Department's Internal Affairs Division and requested a copy of Officer Brennan's body cam footage. Under North Carolina's public records law, he was entitled to it, and as a judge, he knew exactly how to make that request in writing, with legal precision. The footage was provided within 48 hours. Walker reviewed it. Then he reviewed it again, taking notes, time-stamping every constitutional violation, every procedural failure, every moment where Brennan's actions crossed from enforcement into harassment. He didn't call the media. He didn't post on social media. He did what he'd been trained to do. He built a case. On Wednesday, he filed a formal complaint with the police department, attaching a detailed legal analysis of the stop. He cited case law. He identified specific policy violations. He documented the duration of the detention, the lack of probable cause, the retaliatory behavior, and he requested a full internal investigation. The department's response was immediate. Brennan was placed on administrative leave pending review. A supervisor was assigned to examine the footage. Internal Affairs opened an official case file. By Friday, local media had picked up the story. Durham judge files complaint after traffic stop. The headlines were careful, neutral, but the implications were clear. And the body cam footage, once it was released, would tell the rest of the story. As the investigation unfolded, a troubling pattern emerged. This wasn't Officer Brennan's first complaint. Records showed that over his 5-year career, Brennan had been the subject of 7 prior complaints, 4 involving allegations of racial profiling, 2 involving excessive use of authority during traffic stops, and 1 involving discourteous behavior toward a citizen who questioned his actions. None of those complaints had resulted in formal discipline. Most had been marked unfounded or not sustained. In 2 cases, the complainants had simply stopped cooperating with the investigation. But this case was different. This complainant was a sitting judge with the legal expertise to articulate every violation in constitutional terms. This complainant had the resources, the standing, and the credibility to push the case to its conclusion. And this time, there was video. Internal Affairs expanded its review. It examined Brennan's prior stops, looking for patterns. It interviewed his supervisors, his partners, other officers who'd worked with him. What emerged was a picture of an officer who saw traffic stops as opportunities for control rather than public safety, who treated questions as challenges, who escalated encounters unnecessarily and justified it with vague appeals to officer safety or training and experience. It also revealed a department that had overlooked those warning signs. 7 complaints in 5 years should have triggered intervention retraining, closer supervision, a formal review of practices, but it hadn't. Brennan had been allowed to continue operating with minimal oversight, his pattern of behavior normalized, his violations excused. This wasn't just about one bad stop. It was about a system that had failed to hold an officer accountable until the victim had the power to demand it. The internal investigation took 6 weeks. During that time, Officer Brennan remained on paid administrative leave, and the body cam footage released through public records requests began circulating online. The response was swift and predictable. Civil rights organizations called for Brennan's termination. Community groups organized protests outside the police headquarters. National media picked up the story, framing it as yet another example of racialized policing captured on camera. The department's findings were released in late July. The report concluded that Brennan had prolonged the traffic stop beyond the time necessary to address the initial violation, failed to articulate reasonable suspicion for continued detention, engaged in retaliatory conduct in response to the assertion of constitutional rights, violated departmental policies on professional conduct and bias-free policing. The recommendation? Termination. But before the department could finalize that decision, Judge Walker's attorneys filed a federal civil rights lawsuit under 42 U.S.C. Section 1983, alleging Fourth Amendment violations, unlawful detention, and retaliatory conduct. The complaint didn't just name Officer Brennan, it named the Durham Police Department and the City of Durham, alleging a pattern of inadequate training, supervision, and accountability that allowed such conduct to persist. The city's legal team reviewed the body cam footage. They reviewed Brennan's disciplinary history. They reviewed the internal investigation findings, and they made a calculation. This case would not survive summary judgment. A jury would see the video. A jury would hear the judge's calm, measured assertion of his rights. A jury would see Brennan's escalation, his retaliation, his constitutional violations documented in real time. The city couldn't win this case, so they settled. In October, less than 6 months after the traffic stop, the City of Durham agreed to pay Judge Walker $235,000 to resolve the lawsuit. The settlement included no admission of liability, but it included something else. A requirement that the Durham Police Department implement new training on constitutional policing, implicit bias, and de-escalation. A requirement that body cam footage from all traffic stops be subject to random audit. A requirement that officers receive annual retraining on the limits of their authority during investigative detentions. Officer Kyle Brennan was terminated effective immediately following the settlement. The $235,000 came from the city's insurance fund, which meant it came from taxpayers, not from Brennan personally, not from the officers who'd overlooked his prior complaints. From the community, $250,000 paid because one officer couldn't recognize that authority has limits, and because the system that employed him had failed to teach him that lesson. This case is about more than one traffic stop gone wrong. It's about the cost of discretion exercised without accountability, the danger of assumptions unchecked by evidence, and the gap between lawful authority and its abuse. Judge Terrence Walker didn't file that lawsuit because he was personally offended. He filed it because the conduct he experienced, captured in detail on body cam, represented a violation of constitutional principles that should protect every citizen, regardless of race, profession, or familiarity with the law. But here's the uncomfortable truth. Walker's professional status mattered. Not legally, his rights were the same whether he was a judge or a janitor, but practically, because Walker had the knowledge to articulate his rights in real time, the resources to pursue accountability, and the institutional standing to force a settlement. How many others pulled over on suspicion, detained without cause, treated as threats for asking questions, didn't have that power? How many traffic stops escalated the same way, without body cams, without legal expertise, without the ability to fight back? The body cam footage in this case did what it was designed to do. It created an objective record. It removed ambiguity. It made Officer Brennan's conduct undeniable, and it forced the city to pay the cost of behavior it had previously ignored. But body cams only matter if the footage is reviewed, if violations are addressed, if patterns are interrupted before they become civil rights lawsuits. Accountability can't begin after the settlement. It has to begin during training, during supervision, during every traffic stop where an officer confuses compliance with submission. The $235,000 settlement was preventable. The internal investigation was predictable. The termination was deserved. And it raises a question every police department in the country must answer. How many more officers like Kyle Brennan are still on the street, still conducting stops, still treating constitutional rights as obstacles instead of obligations? Because the next Judge Walker might not be a judge at all. So here's the question for you. What should have happened during that stop? Should Officer Brennan have ended the encounter after confirming Judge Walker's documents? Should he have recognized that a citizen asserting their rights isn't a threat? Should the department have intervened after the first complaint, the second, the third, before it cost the city $250,000? If you think body cam footage is changing policing, forcing transparency, demanding accountability, making the cost of misconduct too high to ignore, then hit that subscribe button right now. Because we're covering more cases like this one, more documented failures, more moments where the camera tells the story the officer won't. Drop a comment below. Do you think $235,000 was enough? Should Officer Brennan have faced criminal charges? And what happens to the officers whose stops aren't recorded, whose violations aren't documented, whose victims don't have the power to demand justice? We'll see you in the next one where we break down another case of authority without accountability. Thanks for watching.